Okay, thank you everyone for who's attending this webinar. Our firm's put together a series of webinars that we're offering throughout September. The idea being that the kids are going back to school, so maybe we could all go back to school at the same time, and we've tried to focus on issues that are arising as we start to reemerge from the COVID shutdown. And we're certainly not done by any stretch, but businesses are reopening and offices are reopening, and tribunals. Next week's is about the landlord-tenant board, and that's reopening. So what we're talking about today is reopening a unionized workplace post-COVID shutdown. And let's hope that I can, there we go. So just by way of an overview, we're going to talk about four main topics today, and that's not to suggest that those are the only four topics that you might come across, but they were four that struck me as particularly relevant, and one of them is kind of a catch-all anyway. But the four we're going to look at are your responsibility for ensuring a safe workplace as an employer, how to deal with reductions in work and recalling laid off employees. And this is the catch-all, just generally complying with your collective agreement. And then we're going to talk a bit about unfair labor practices, which is a whole basket of things that you cannot do according to the Ontario Labour Relations Act, which applies only to a unionized workplace. We've got some time at the end for questions, but if you have a question during the course of the presentation, by all means, feel free to jump in and ask it. I have Fraser Pages moderating, so I'll either see it, and if I don't, he will, and we'll make a decision of whether or not to answer it right then, because it's a good segue from whatever we're talking about, or to park it to the end when we deal with questions generally. So again, by way of the overview, we're going to try and focus here on issues that arise by virtue of your workplace being unionized, and issues that will arise in respect to your unionized employees. Even at that, as I mentioned earlier, we're only going to be able to focus on some of them, some of the issues, because there are probably as many issues as there are, or potential issues as there are grains of sand on the beach, and you can never anticipate everything that's going to come up. So we're going to try and take a look at some that seemed a little more likely to come up, and hopefully going through those will give some sort of idea about the thought process you should approach this with as well. Now you'll probably have some non-unionized employees to whom these issues will likely not apply. For example, you know, the rules about how you recall employees from a layoff that are applicable to your unionized employees won't necessarily apply to the non-unionized employees. And in addition to whatever obligations the collective agreement provides, you'll also have obligations under legislation like the Employment Standards Act or the Human Rights Code that will apply to all of your employees. Now, sometimes the collective agreement will require more stringent requirements. In fact, usually it'll require more stringent requirements than the law at large requires. I mean, that's the whole point of unions, is to get a higher wage and minimum wage under Employment Standards Act and get more vacation than required under the Employment Standards Act, et cetera. So it's likely that your collective agreement will call for more stringent requirements in respect to your unionized workforce. But there may be areas where the collective agreement doesn't speak to an issue. For example, certain types of leave may not be addressed in your collective agreement. And in that case, if they're required by the Employment Standards Act, you still need to provide them. And one of the areas where this might be an issue that's relevant to opening up after COVID is the concept of sick leave being used to care for members of your family. Because with the back and forth in the Employment Standards Act with how sick leave and family responsibility leave was treated, the former Liberal government passed some legislation that broadened it and tied them together under family responsibility leave. And the Ford government brought those back so that they're no longer, well, it's switched back and forth a lot. And collective agreements, because they don't follow the law necessarily each time the law changes, they're for 3 or 5 year terms typically, may not capture that. So you might have obligations for an employee who's unionized, who comes and says they need time off to care for a child or a spouse who has COVID. And you'll have to be mindful of your Employment Standards Act obligations in that regard. I want to point out that 2 weeks from today, one of my colleagues will be giving another webinar, and her subject is going to be non-unionized reopenings. So I would recommend that you sign up for that, because to the extent you have any non-unionized employees, or to the extent that some of the legislation provides for more stringent requirements than your CA, or provides for situations that your CA doesn't cover, Sophia's talk on the 30th will be very helpful. So just a standard disclaimer, we're here to provide legal information and not legal advice. And it's hard to know where the line is drawn, but I like to think of it as a situation where legal advice is your particular situation. You come to me and say, here is my issue, and the details become very important. And the reason that we draw that line in these discussions is that it wouldn't be fair to me or you or the others who have to listen to our chat if you were to go into a lengthy discussion about the details of your situation so as to get legal advice applicable to your situation. So instead, what we do in these webinars is to focus on some broader issues, hopefully in a way that will let you figure out or realize that you might be in a situation where you do need legal advice. For example, we'll talk about your obligation to reopen the workplace and have a safe workplace, and hopefully that talk will let you know if you should be asking more detailed questions, seeking legal advice, whether from us or your other lawyers. And if we get to that line, I'll try and nicely say we can't go there. But first, a word about management rights. Now, your collective agreement will almost certainly contain a management rights section that sets out what rights you retain. And it'll be something along the lines of, you have the right to maintain order, discipline, efficiency, to establish rules, to amend the rules as long as they don't violate the collective agreement, to hire, to assign duties, to promote, to lay off, to terminate, to classify employees, to discipline them, to suspend them, to determine the number and qualifications of staff you need, standards of performance, working hours, the sorts of services to be provided, et cetera, et cetera. And on top of that, in Ontario anyway, management also has residual rights, which means that if a matter is not addressed in the collective agreement, the manager has the same rights in respect to unionized employees as it does in respect to non-unionized employees. And those are about the only rights that you will get under the CA. The CA, I think, is designed typically to get rights for labor. As I mentioned, the residual rights are really where your big bucket of rights are going to be, where something isn't dealt with in the collective agreement. You have the same rights you do for all of your employees. But regardless of how big a bucket of right that leaves you, all of those rights have to be exercised in a manner that's consistent with the rest of the collective agreement. So for example, if your collective agreement says that, this is the harassment procedure or the procedure to investigate a claim of harassment, you can't implement a different policy or treat harassment claims differently. Even though the management rights will say, you can amend policies because you need to amend that policy in a way that's consistent with what the CA provides about it, at least as far as it affects your unionized workers. Now, unions will typically resist efforts by management to rely on management rights or residual rights if management wants to make changes to the workplace, whether it's hours of service or hours of work or duties. They will try and establish that the CA provides for it specifically or provides for it by analogy, so that you're constrained in how you exercise those rights. And a lot of disputes I see anyway are and a lot of the questions I get are related to, can we do this, or do we have to involve the union? Is it within our management rights, or is the union going to take the position that it's something that's covered by the CA? Why I mention that here is that it will be hard to tell how arbitrators and adjudicators will respond to efforts to rely on management rights. Let's take an example of hours of work. If we are talking about a situation, and we'll talk about this a bit more later, but if we're talking about a situation where you want to have cohorts of workers, say your regular hours are 9 to 5, but all of a sudden you want to change it to, say, 6 to 1 and 1 to 8, so that you don't have, you can socially distance a bit better or maintain physical distances between your workers to a greater extent. And let's say your management rights clause says that you can, set hours of work. The union will probably resist that and will say that, it's implied that they're during regular work hours, or since we provide for the hours of work, by analogy, they've got to come to us and negotiate, or in some other way, they'll try and uphold the employees' rights to a regular 9 to 5 shift, if that's what the employees want. And to be brutally frank with you, I can't tell you as I sit here today how arbitrators or adjudicators will resolve that dispute in light of the fact that you're changing those changes, or you're making those changes to address the pandemic, because nobody anticipated a pandemic like this. You know, the last time there was one that was similar was 100 years ago, and you know, the laws have changed a tremendous lot since then. So it's not as though we can go back to look at precedent when they had the Spanish flu pandemic and apply those lessons to today, because there wasn't an Employment Standards Act and there wasn't a Labor Relations Board and so on and so forth. There wasn't an Occupational Health and Safety Act. So at the end of the day, the last bullet, you know, says if you're going to rely on your management rights or residual rights to try and implement a change as you reopen, so be it. That's fine. But the more certain approach is to try and act in a manner that complies with the CA. And before going on to the substance of it, and back to the issue of the details being the difference between what's legal information and legal advice, you know, every collective agreement is different, and there'll be an example coming up shortly about how they differ greatly. But it's hard to give you a one-size-fits-all answer to how to deal with these sorts of things. If you were to come to me with a question about your particular workplace, probably my first question would be, do we have your collective agreement? And if the answer were no, my second question would be, can you provide me a copy? Because we need to see what your contract says before we can tell you what your particular rights are, whether it's under management rights or whether we make a case that it's residual rights or whether there is a specific provision in the Employment Standards Act. In any event, moving on to responsibility for a safe workplace, even if your workplace is not unionized, you're required to provide or to take reasonable steps to ensure that the workplace is safe because of the application of the Occupational Health and Safety Act. And that act applies to unionized workplaces and non-unionized workplaces. And in respect to both unionized employees and non-unionized employees, it also gives most employees a right to refuse work if they have a reasonable belief that there's something unsafe about the work. And I say most employees because, for example, prison guards are excluded to the extent that they're complaining that they have to guard dangerous prisoners. There are some jobs, police officers and firefighters, for example. There are some jobs where it is inherent in the job that there is a unsafe part of it. So, you know, those sorts of employees don't have the right to take, they aren't completely prohibited from refusing work if there's a reasonable belief there's something unsafe. For example, if a ladder a firefighter is asked to climb is missing rungs, they can say that's unsafe and it's not inherent in the work that I've got to use an unsafe ladder. But if you say go into a burning building and get somebody, that is something they couldn't refuse to do under the Occupational Health and Safety Act. For most of the people who are watching this seminar, my suspicion is that your employees will not fall under any of those exclusions. So they'll probably all have the right to refuse unsafe work. The key in COVID is that the belief that the work is unsafe has to be a reasonable belief. So they can't just say, because there's COVID, it is unsafe. The belief has to be reasonable, and there's a process for resolving disputes about whether or not it's a safe workplace. I'll talk about the process in a second, but the second point I want to make about an employee's belief that the workplace is unsafe has to relate to the work itself. What I'm trying to say here is, if your employee were satisfied that you'd put in appropriate measures for social distancing and to protect their safety at the workplace, but they were complaining that they had to take public transit to get to work, that wouldn't give them a right under the Occupational Health and Safety Act to refuse work. It's not getting to work, it's not getting home from work, it's the unsafe situation has to be something to do with the actual workplace itself. So to the process for resolving disputes, the short story is an employee comes and tells their supervisor that they are refusing work because they believe there is something unsafe about the workplace. The employer and a representative of the worker, and in the case of a unionized employee, the representative from the union, likely the steward, would investigate and would make a decision on whether the workplace was unsafe or not. If they determine the workplace is not unsafe, they would tell the worker, and the worker could either agree and start working or could maintain their position that it was unsafe. In which case, the employer could contact the ministry and have an inspector appointed by the ministry come and make a determination of whether or not the workplace was unsafe or not. Another alternative is that when the employer and the union representative inspect the complaint, they find that, yes, there is something that needs to be done. To use an example relevant to COVID, if, for example, you have plexiglass cubicles, for lack of a better term, to try and protect your workers, and one of the panes had fallen down, and your employee says, I'm not working because the plexiglass pane has fallen down, and as a result, Joe and I are breathing the same air. Then you would likely say, okay, well, here's the step we need to take to resolve that. We need to reinstall the plexiglass pane. You would do that, and you would say, okay, worker, now we've reinstalled the plexiglass pane, go back to work. And the worker could then still say, no, I'm not satisfied that it's safe because it needs to be disinfected or something like that. And in that case, you could again reach out to the ministry for an inspector to come and inspect the situation and to find out whether the workplace was safe, and they'd make a decision. Now, an important thing from this is that you typically cannot anyway, punish an employee because they refuse to work on the basis that it's their belief that there's something unsafe about the work. The Occupational Health and Safety Act says you cannot take a step of reprisal against an employee for exercising that right. That said, there are cases that hold that if you can demonstrate that the employee is abusing that right, that they really don't have a reasonable belief that there's something unsafe about the work, or that they are claiming a reasonable belief or a belief that there's something unsafe about the work because they want the day off for some other purpose. Or if they make continued claims about the same issue after an inspector has determined that it is in fact a safe workplace, you might be able to say they're using it vexatiously, and on that basis, discipline them. But that is by far, that's the exception. The rule is that you cannot discipline them for exercising this right. So then we get to what your CA says. And some of your collective agreements will essentially mirror the requirements of the Occupational Health and Safety Act and consider that to be enough, in which case you deal with it the way I just described. Others, though, will introduce additional requirements. By way of example, I've seen collective agreements for daycares where the health and safety provisions provide that if there is a head lice outbreak because of all the children, that the employer will provide the employees with the appropriate medicinal shampoos. I have seen situations where there are maintenance workers and there are requirements that places where they have to work with solvents and cleaners are adequately ventilated to protect their safety. I've seen situations where there are office workers and there are requirements under the joint health and safety or the health and safety portion of the collective agreement that says that they have to have time off. Every hour they get 5-minute break, or every 2 hours they get a 5-minute break so that they're not constantly staring at a computer screen. So that's what I was alluding to earlier when I said there can be big differences in what's required of you under your collective agreement. There are other big differences as well, but as I said, if you were to come to me and say, do I need to do this? My first question would be, let's see what your collective agreement says. One area where it's not so sector specific that CAs often require something in addition to the Occupational Health and Safety Act is that they can sometimes require a joint health and safety committee, even if the Occupational Health and Safety Act doesn't. Now, the Occupational Health and Safety Act requires that you will have a joint health and safety committee if your workplace typically has 20 or more workers. But a collective agreement might have applied to a workplace where there are 10 or 15 workers and require a joint health and safety committee. Alternatively, it might require a health and safety representative of the union that management will meet and discuss matters with. So if you do have such a representative, and if you do have such a committee, I would recommend that you involve the Joint Health and Safety Committee in discussions on how to reopen safely. Typically, the committee will inspect the workplace. They'll meet 3 times or 4 times a year, unless someone asks for a meeting more frequently. And they'll make recommendations to management, and management then has to respond to the recommendations either by acting on them or by explaining why they're not going to act on them. So that's why I say, you know, you can invite their input without letting them make the decision. And what I would suggest is that because management has representation on the committee as well, that management say, we'd like to have a meeting, even though our next meeting isn't scheduled until December, say, we'd like to have a meeting now because we're reopening and there may be issues, and we'd like to have a full and frank discussion on where people might think there are health and safety concerns. You'll have to respond to those, but I really think this might be a situation. I'm sorry, you have to respond to them. And by responding, that doesn't necessarily mean that you've got to adopt them. But I really think this is a situation where by having that discussion at the outset, an ounce of prevention may be worth a pound of cure. You'll also want to review your collective agreement to see if it contains any specific provisions relating to your workplace that might be relevant to COVID. And you'll remember I talked about the head lice shampoo and the computer screen breaks. But the other one I used was a situation where maintenance employees might be required to work in a place with adequate ventilation. Now, while that provision has been put in, presumably to discuss or to address fumes from solvents and what have you, it is also arguably relevant to a disease like COVID. So you would want to check your CA and see if it contains those sorts of conditions, whether it's ventilation or whether it's providing protective equipment. Even if when you negotiated that clause, you didn't have COVID in mind, it might be relevant. And if it does, you'll need to make sure that you follow those requirements. Beyond that, and this is relevant not only to unionized employees, but it's worth mentioning here, you'll need to be aware of whether there are any specific requirements for your sort of workplace. For example, restaurants, food service providers have requirements that an office probably doesn't. Daycares have requirements, and long-term care facilities have requirements that a video store or a corner store may not have. What you want to do is make sure that you comply with all of the laws and regulations and government guidelines and any requirements of any professional governing bodies that apply to your workplace. For example, to go back to daycares, there's an act requiring licensing of employees, and that act sets out a governing body that you'll want to contact to see, for example, if there are any sector-specific requirements of reopening. At the end of the piece, there's a resource page that has a reference to a general, let's just go to it right now for a second. Right there, it's got the regulation for rules for areas in stage 3, and that sets out things like, if you serve food that you can't do it buffet style, and how many people have to be in place. And it also sets out general requirements for businesses that are reopening. And then there's also a link there to a provincial government web page on resources to prevent COVID-19 in the workplace. And that web page has, among other things, some sector-specific resources that it links to. So I recommend both of those resources so that you can make sure you're on, that you're complying with all the laws and regulations. I would also recommend that you assign somebody to check that those websites periodically, because the regulations are changing frequently, less rapidly than they did at the outset, but they're still changing frequently. Then we get to reductions in work. We're calling laid off employees. And this is the area where unionized workplaces probably differ the most from non-unionized workplaces, because one of the 2 or 3 biggest elements of most collective agreements, if not all collective agreements, is to protect job security for employees. And one of the biggest ways they do it is through seniority, the seniority idea where, if you have to lay people off, you do it from the bottom up. Again, depending on whether there are any specific differences or provisions in your collective agreement. So the first question you want to ask is whether you anticipate that you'll have any permanent reductions in your unionized workforce as a result of the pandemic. I think when people were laid off, and when businesses had to lay employees off, the hope was, as the pandemic passed, you would eventually get back up to your pre-pandemic level of business. But the reality is that's not going to be the case for everybody. And if you are going to have permanent reductions in the unionized workforce as a result, that's something you need to address. And the first step in doing that would be to look at your collective agreement and see whether it contains any provisions that require you to notify the union of permanent layoffs. Some of them will actually say, if you're going to have permanent layoffs, you have to meet with the union to try and discuss alternatives, to see whether there's a way that you can mitigate the impact of the reduction in the workplace. And again, while meeting with the union sometimes invites more headache than it addresses, than it solves, this might be a situation where even if your collective agreement doesn't require you to meet with the union, you might want to do it anyway. And the reason for that is you may be able to discuss a situation where you can offer packages to lay off your more senior workers if that suits you. Alternatively, you may be able to avoid layoffs if they'll agree to reduced hours and essentially job sharing. So the message here is it may be helpful to discuss these issues with the union, whether or not you have to. But one thing you need to do is to check your CA and see if it requires you to do it. And if it requires you to do it, then you should do it as soon as possible, because typically those sorts of provisions will also require that you give a certain amount of time for the union to try and suggest alternatives. And that's going to put back your the date on which you can implement the reductions. So again, you'll need to take a look at the CA, see whether you need to notify the union, whether you need to discuss or have meetings with the union, and get that process underway as soon as you come to the conclusion you may have permanent layoffs as a result of the pandemic. You should also consider whether any particular areas in your business will be opening at different rates than others, and what your collective agreement provides for in recalling employees. To use a bad example, but one that came to me as I was trying to puzzle out how to explain this, if you have a banquet hall that also does catering services, you may be in a situation where you can't reopen the banquet hall, or where there's nobody's booking banquets now because of social distancing. But they are catering events and takeout food, essentially. So you may need to rehire your cooks and chefs or recall them while not recalling your serving staff. So if that were the case, you'd need to look at your collective agreement and see whether it provides that just for straight seniority, where the most senior employee gets recalled first. And if they're the one who gets recalled first, is there a provision that says, provided they can do the job that is being recalled without training at all, or with 2 weeks of training? And that all sorts of brings into issues like the metrics. I mean, they may be able to cook, but not as well as one of your trained cooks, but you might be in a position where that's not the metric. It's just whether or not they can actually cook. I don't know how many banquet halls are in our audience today. I imagine none, but in your particular situation, you may have maintenance workers and office admin workers. And are you going to have to recall a maintenance worker to do an office admin job or not? So, like I say, you need to consider whether different areas of your business are going to be recalling employees at different rates. And if so, what your collective agreement provides for. I've seen collective agreements that provide that layoff and recall is done, in essence, in silos. So it's not a wide open seniority issue. It's seniority within program coordinators, seniority within consultants, seniority within the IT providers. So that takes care of a bit anyway of worrying about whether or not you need to bring back all your IT people because everyone's working remotely. Do you have to hire back John in you know, accounting to come in and do the IT function because he's got more seniority? So again, it's all going to boil down to what your collective agreement provides for. And in the context of bumping categories, in the context of layoff and recall categories, in the context of whether training is required and how much, and in the context of how you measure whether somebody is able to do the job or not. So complying with your collective agreement. I mean, that goes without saying. If you don't comply with your collective agreement, you're inviting grievances. But it is relevant to point out simply because the collective agreement was probably negotiated without a pandemic in mind. So some provisions that seemed inconsequential at the time you were negotiating may have an increased significance as you're reopening. And I spoke earlier about the prospect of having cohorts of workers come in at different shifts. What does your collective agreement say? Does it say that the hours of work are going to be the normal business hours? I've had situations where employers wanted that sort of provision built in so that they didn't have to address people who requested flex time. On the theory that if the collective agreement simply says you've got to work, 7 hours a day, 5 days a week, you might be inviting people who say, I want to work, Tuesday to Saturday, and I want to work from 7 to 3. So days of work, hours of work are provisions that you might have in your collective agreement. And if you want to opt out of them, you may need to discuss that with the union. Similarly, workplace standards. I've seen situations where the collective agreement says the employer will ensure that the workplace has the appropriate ergonomically correct furniture and will have the appropriate computer equipment and internet hookups to be able to work. And if you are going to have your workers work in cohorts, maybe part of your plan is to have half your workers work remotely on even days and half of them work remotely on odd days and come into the office on the other days. And if that's the case, what does your collective agreement require of you as far as providing an appropriate equipment and furniture for the workplace? And how does that translate to when you're having them work from home? So again, you need to look at the collective agreement and see if any part of your plan varies. You need to assess your plan for reopening and see if there are any points of tension with the collective agreement. And if there are any points of tension or areas where your plan for reopening would conflict with the collective agreement, you need to involve the union in discussing a deviation from the requirements of the CA. And the method of addressing the issue may vary. It may be done by a letter of understanding, but if you're only doing it for a month, it might be enough to have an exchange of emails where the union confirms that it agrees with this approach. But whatever the method is, make sure that the union's agreement with that approach is confirmed in writing, because you don't want to have to prove later that they said it was agreeable. There's as much as you'd like to think that, as much as you might like to think that truth always finds a way in lawsuits or arbitrations or adjudications. It doesn't. There's often a difference between what you can prove and what really happened. So in this instance, if you're going to deviate from the collective agreement and you're going to get the union on side with it, make sure that their agreement is in writing. Last thing I want to speak about is the issue of unfair labor practices. And this is something that applies to the unionized part of your workplace as a result of the Ontario Labor Relations Act. And it sets out a whole bunch of acts, some by management, some by union or workers, that are deemed to be unfair labor practices. But two are particularly relevant to the concept of reopening. The first is that you cannot bargain with any party other than the union in respect to members of the bargaining unit. And the second is that you cannot punish an employee for involvement in the union. So to look at cannot bargain with any party other than the union in respect to members of the bargaining unit, if you're discussing changes to the conditions of employment that aren't within your management rights, you will need to speak not only to the affected employees, but also to the union and get the union to agree to any changes. Go back to this hours of work idea. If you were to say you knew that a certain employee would rather work an early shift, and you went to that employee and said, listen, would you like to work in off hours, be part of our off hours cohort? And they said, of course I would. And they agreed to it. And you implemented that without involving the union. You have in theory negotiated with someone other than the union in respect to one of its members, which is an unfair labor practice. So when you want to approach Charlie about the prospect of this, or another example, if you are having to reduce your workforce and you know that Charlie's been thinking of retirement, and you want to say to him, would you take a permanent layoff with a package so we don't have to lay off permanently one of the more junior people, you need to involve the union in that discussion from the outset. And in fact, you might speak to the union first and say, Charlie's often said this, we'd like to discuss this with him. Or we'd like to discuss this with the members at large, see whether any of them want to take a buyout. Do not approach the union members directly without first having engaged the union. If you do, you're negotiating with them, and that invites a claim that you've engaged in an unfair labor practice. And the second, not punishing an employee for involvement in a union. And I put punish in quotes. That's not the exact word that's used. And in the context I'm about to speak of it, it's not really punishment. It is a situation, though, where, for example, if you wanted to have a change to the workplace and one of your non-unionized employees asked for an accommodation. Let's say they asked to be able to work their regular hours still because they had to care for someone at home and couldn't rearrange their health care when they're away to let them work a cohorted shift. That would be a preferential treatment to a non-unionized employee, and it wouldn't be done to punish the unionized employees, but a unionized employee might say, I too want to work my regular shift. And if you were to say no, you might face an argument, however ill-begotten, that you are punishing that employee by not letting them have the same benefit that you're giving the non-unionized employee. And the only difference between them so goes the argument, is that the employee you're not giving the benefit to is a union member, so you're punishing them for being involved in the union. I don't say this to say don't give any preferential treatment to any employees, whether unionized or non-unionized. In fact, you may be required to do so under the Human Rights Code, depending on what the reason they're asking for that treatment is. What I am saying is if you're going to give preferential treatment to any of the employees, but particularly one who's not in the bargaining unit, make sure that you have a good reason and that you have documented the reason. And you'll see in brackets, I say, for example, you might be providing an accommodation to address a human rights issue. So you want to be able to say, it's not because Joe's in the union, it's because Bob has a doctor's note saying this, that, or the other, and we have to accommodate Bob's disability or Bob's family situation or whatever the case is. But you want to try and avoid a situation where it looks like you are treating a unionized employee in a manner that they might construe as punishment. And if you have to give them differential treatment, you want to make sure you've got a good reason for it. So that takes us back to this resources page that I shot to earlier. You know, there are a bunch of different possible resources that might be relevant, but they're also sector specific, and they're also specific to what your collective agreement provides. But I thought the best resources were these two, the general rules that the government has imposed for reopenings, and then a general government web page that also contains some sector specific requirements. And I mentioned that we have this back to school program. You'll see mine is the third of 5. I am given to understand that after we do them, they're all put up on the firm website. So if any of them interest you that have already passed, you can certainly go back and review the seminar. And there are 2 that are coming up. Again, they're all good, but I highly recommend Sophia Lacani's September 30th one to people who are interested in this particular webinar, because she will canvass the issues of returning to work from the perspective not of unionized, but in a more general manner. So hopefully that has been helpful, and I didn't notice any questions pop up during the seminar, but now we've got a few moments left, I think. Fraser can tell me if we don't. And, you know, I'm happy to stay on to answer questions if anybody has any.
We have a few more minutes.
Pardon me, Fraser? Oh, we do have a few more minutes.
I just jumped in to say that we do have a few more minutes if anyone has a question.
I am always unsure when I get no questions, if it's because I covered the material so fantastically well that I answered all of your questions, or if it was so dry and uninspiring a subject, or handled in so dry and uninspiring a way that nothing popped to mind. Let's see, we've got a chat here. Oh, thank you very much. I appreciate that. I know that the comment is I speak slowly to cover this stuff off, and I know it's a little dense sometimes, so I want to try and do that. I think it's better to cover a few issues in a way that you can take them away than to cover more issues and burn through them, and it's hard to keep track. So, you know, even though this is a bit early, not terrifically early, but a few minutes early, if there are no questions, we can probably bring this to a close. And I want to thank you all for coming and spending this hour with me, and hopefully it's given you some food for thought as you plan your reopening and try and navigate these uncertain shores, as it were. We're all in the same boat in that regard. And, we're happy to help you as best we can with any of these things. I think the most important thing, though, is that you go into this whole process with a bit of awareness of the sorts of issues that might crop up, which will help you spot when those issues do arise. And I hopefully I've managed to do that today. So seeing no other questions or comments, thank you all very much, and enjoy the rest of your day.